Confidentiality in Healthcare, Medio IGC 303, Unit 5. I'm Dr. Isabel Souza, your presenter for this unit. So, we're going to talk a little bit more about confidentiality. Medical records should not be released to third parties without the patient's written consent. And don't forget, when we say consent, there has to be proof that they understood what they were consenting to. So if they speak French and they're signing an English consent with no indication, that could cause trouble in the future. So that's why we need to be there. Only specific records requested should be copied and sent. So most of these consents are very specific of what can be sent to another party. Taking photos or other visual images of patients without consent is also an invasion of patients' privacy. So let's move on. Ownership. Physicians or owners of healthcare facilities own the medical record. Patients have the legal right of privileged communication, and they have the right of access to all records. Patients must release and authorize the release of records in writing. That's very important. Sometimes patients don't understand why, and we just, as interpreters, we just explain that this is a common practice in our healthcare system. Moving on, ownership 2. There's something called the doctrine of professional discretion. The physician may determine, based on his or her best judgment, if a patient with mental or emotional problems should view a medical record. So this is a particular protocol or doctrine for physicians. Let's move on. And let's talk about the release of information a little bit more. Again, the record cannot be released without the physician's permission. The patient must not sign a release form for the information to be sent to an insurance company. I'm sorry, the patient must sign a release form for the information to be sent to an insurance company, or to anyone for that matter. Never send the entire medical chart unless it is requested. So again, confidentiality also has to do with, only providing the necessary information for the necessary reasons with the necessary consents. So it's not an all or none situation. Moving on. Privacy Act of 1974. The agency may obtain only information relevant to its authorized purpose. Citizens have the right to gain access to records and to copy of the records if necessary. They should be able to copy them. And this applies only to federal agencies and government contractors. So as you can see, this is a Privacy Act that preceded HIPAA, which came at a later date. But the Privacy Act is an important act, so we're mentioning it here. Let's move on. State open records laws. Some states have freedom of information laws that grant public access to records maintained by state agencies. So that's important for us to know. And medical records, however, are generally exempt from this statute. So, these are the type of laws that, allow us to see our own credit scores and other public records that are out there. But medical records, because of the confidentiality issues with medical information, are exempt. Moving on. Alcohol and drug abuse patient records. So Public Health Services Act protects patients who are receiving treatment for drug and alcohol abuse. And this is due to stigmatization of those patients. And a person or a program that releases confidential information relating to these patients is subject to criminal fines. So it's a pretty serious offense. Exception if patients should require emergency care. So it's important to know the exception. Moving on. Retention and storage of medical records. Each state varies on length of time records must be kept. So in the US, we go state by state. Legally, records must be stored for a minimum of 7 years from the time of last entry. And minors' records must be kept until a patient reaches the age of maturity plus the period of the statute of limitations. Moving on. This is just so we understand the system better. Computerized medical records. So, there are hospitals that still utilize heavy binders with a lot of medical information and have an outdated system, but the majority of hospitals and clinics are using computerized medical records or electronic medical records, sometimes also referred as CMRs or EMRs. So data on a patient's records can be created, modified, authenticated, stored, and retrieved by a computer. And there are some large companies out there like Epic and Meditech. Those are the two largest ones that provide electronic medical records across the country. And some of them are actually adding language fields to the patient records, since we have, laws in many states that require healthcare organizations to document the preferred language of service of the patient right on the medical record. So that's a very important thing. And now certain medical records actually require the provider to acknowledge and document how the language need was met. And it's a hard stop. So unless they document that, they can't move on into, as they're working on the medical records. So if you ever see a provider constantly on the computer, many times it's because they have to document everything they're doing in the patient's medical record. So special safety measures should be taken to establish personal identification and user identification codes for the access of those records. So it's quite a feat that some hospitals allow interpreters to even access medical records, because frankly, very few individuals can access medical records, typically only the nurses and the providers of those patients. So these records should be accessed on a need-to-know basis. Again, even when you do access a medical record, you may not have access to everything in that medical record. So let's move on. Always due to the confidentiality security issues. Reporting and disclosures requirements. So state laws require disclosure of certain confidential medical record information without the patient's consent. And we've discussed two of them. Hopefully you remember. When patients threaten to harm themselves or others. But there are other, very rare situations where states may have differences in disclosure. Let's move on. Or the duty to report AIDS and HIV cases. So all states require the reporting of AIDS to local and state departments of health. And frankly, many of them require it for other contagious diseases as well. Now, most states require HIV cases to be recorded as well, so not all of them, but AIDS, every state. So who reports it varies state by state, and many states have confidentiality statutes that allow the notification of an HIV patient's spouse, needle sharing partner, or other contact person who is at risk of the infection. So, certain states are changing their laws and creating the ability for tracing and protection of other patients. And, you can say this is one of those cases where the lack of sharing the information will cause a patient harm or injury, another individual, that's why it's an exception. So this is where we're going to end this presentation. Oh, I'm sorry, forgot. We have the use of the medical record in court. An improper disclosure is when healthcare providers and institutions may face civil and criminal liability for releasing medical records without proper patient authorization. So improper disclosures can really cause a liability issue for the providers. And we've mentioned before the subpoena duces tessum, which is Latin for a written order requiring a person to appear in court, give testimony, and bring information described in the subpoena. So that is bringing things forward. So this is the last slide, and I thank you very much for listening.